I can tell you what our answer is in the Guantanamo litigation, but Gabor, did you want to respond? Did you? Yeah. No, Professor, you're the best.
Okay. One, I totally agree with you. The problem is, under the Geneva Convention, and this is the problem that we had during the conflict in Iraq, was that you had people, that the Geneva Convention allowed you only to attack someone if they were participating in the hostilities. And so what that means is that a person could be a civilian selling fruit during the day, engage in an ambush at night, and then if you didn't catch them during the ambush, then you couldn't target them. But they can go back to being a salesman the next day. And so this is the point that I'm making, that the law, and I think the ambassadors make that in some ways the law was inadequate for our purposes. And this is the point that I'm driving in terms of the ability of the law to control conduct. What we should have been doing was perhaps arresting people and making determination as to who they were, but we started resorting to use of the predator and using a number of targeting mechanisms to combat that type of threat that arguably was outside the strict letter of the Geneva Convention. Oh, sorry.
Professor Fletcher, I think we're conflating two questions.
There's substantial lack of settlement on what constitutes direct participation in hostilities, which then determines whether or not someone is targetable. And this is a project that the ICRC and the Asser Institute have been working on for years, and there's been quite a bit of progress, but it hasn't been finalized by them. It's certainly a question that needs to be honed down further. That, however, I think does not have any bearing on the question of status. The Fourth Geneva Convention says that you are protected by this convention as a civilian if you are not protected by the Third Geneva Convention as a POW. It is a default status with minor exception for individuals who are, citizens of the detaining authority or of neutral powers. Everybody is going to be one thing or the other in international armed conflict. So the question that you raise about status is a very live one, I think, in relationship to non-international armed conflict, but it shouldn't be controversial in relationship to international armed conflict.
Professor Sands, did you have anything that you wanted to?
Ambassador Crosswood, because I'm just slightly concerned, with great respect, for your recollection of the facts, and I just think it's important. Facts are important. The decision that was taken by the President on the 7th of February 2002 in relation to Guantanamo had the effect, of course, of casting many individuals into a legal black hole. And your colleagues in the Department of State were acutely aware of that. That decision did not accord with the recommendation of General Powell, and it did not have the support of your legal advisor, Will Taft. And recognizing the consequences of that decision, which I think has been correctly stated by Gabor, Mr. Taft wrote to Jim Haynes the following month, in March 2002, and said, in light of this decision, could Mr. Haynes accept to confirm that all of the detainees would nevertheless be governed by the rules of customary international law, which you've just referred to, in relation to their treatment, detention, and interrogation. And Mr. Haynes wrote back to say no, he could not accept that. There was a clear policy decision, in other words, to cast a large number of people into a legal black hole. And what I'm curious about is, in light of your role and I say this with great respect, in the State Department as ambassador at large with responsibility for war crimes, the consequence of this, of course, is that you were part of a governmental organization which was, in effect, on the edge of an abyss about itself to engage in acts which might amount to war crimes. And I just wonder, in light of the decision given by Mr. Haynes to Mr. Taft, did it ever occur to you that these were conditions in which you ought to resign?
Well, the answer is no. The answer is, first, my memory is very clear. More clear than you would imagine, because I was in the midst of all these discussions and would talk to the Secretary, General Powell, every day on these issues. We, as a department, took a position but we also recognize that from a legal perspective, there was some murkiness. It wasn't an absolute clear black and white issue, because, as I keep mentioning, there are complexities. We keep talking about the Geneva Conventions, which obviously are important, but the Geneva Conventions were not created and passed saying this will become the end-all, be-all governing body of law. When we get back to this question of combatants and status, it did not supplant or take over the Hague Conventions of 1898 or 1907, which gets right into the question of status of individuals, whether they're lawful or unlawful combatants. So there's some real open questions that were there. So our job was obviously to continue to try to influence the process. We took a position, it wasn't agreed to, so we were pressing on having the detainees and others getting what we believe to be the proper treatment.
Do I have time for one more, or am I out? They tell me I'm out. Hopefully we can ask questions for individuals afterwards. Please join me in welcoming our